Alright, today we're going to be looking into a post by Kiwi Farms user Alexander Hamilton, who claims to be a lawyer, and we will be reading his post, and this is going to be going over the potential charges that Chris could be charged with, and what may happen in the result of it, whether it will be a plea deal or anything like that. This is merely speculation and is not legal advice, as he says later on. Anyway, let's get into it and enjoy the video. Alright, so Chris has officially been arrested. 6 p.m. yesterday, August 1st, he was arrested at his motel and taken in by the police. He's been charged with incest. Today I'm going to be reading a post by a lawyer on Kiwi Farms, and it's going to be going over a few of the things. It's going to be very long, but I think it'll be worth the read, especially considering everything that's going on. Standard lawyer disclaimer. I'm a lawyer, but I'm not your lawyer. Nothing I post is legal advice. Nothing I post creates an attorney-client relationship. So I've seen speculation and some actual legal information from other lawyers scattered throughout various threads, and I thought it might be useful or interesting to have a thread for legal issues. I'm a prosecutor, not in Virginia. That's about all I'm going to say on that, and you'll just have to take my word for it unless the admins care so much about me, claiming that they demand to verify me somehow, and then I'll talk to them. This is my perspective on the legal side of this whole mess. If that's not something that's interesting to you, don't bother reading further. Possible charges. So it looks like we've got multiple counts of some sort of rape and probably multiple counts of some sort of abuse / exploitation of an elderly person. And one count of, so far, violating an EPO. What do I mean by some sort of rape? Well, as you're probably aware, the law doesn't actually treat rape as a single monolithic crime, and often the law has special rape laws for when someone appears to consent but is legally unable to, such as in a case of minors. You'll often see this referred to as statutory rape. Again, I'm not in Virginia, and state laws are going to vary. Abuse / exploitation of an elderly person. At bare minimum, it looks like financial abuse. Chris apparently has control of Barb's accounts and is liberal with them. It could be other kinds of abuse too, depending on what they can prove has been going on. Violation of the EPO. The EPO forbids crimes against the protected person, Barb. A lot of the analysis I've seen has focused on theft in terms of the $750. I don't love that charge for a few reasons. One is that the required elements may not be present if Chris had control of the accounts. The bigger reason is that theft of that sort of amount is typically a misdemeanor. Financial abuse / exploitation of the elderly is typically a felony. The rapes of whatever kind are all going to be felonies also. In most jurisdictions that I'm aware of, violating an EPO for the first time is a misdemeanor. But Alexander, if they don't get the DNA, Chris is just going to get away with it again, right? Well, actually no. I've seen a lot of variations on this commentary, assuming that they can be authenticated. The various confessions are actually far and away the best evidence if this went to trial, even if they got DNA. Why? Well, the defense has many lines of attack on DNA evidence, none of which require Chris to testify and expose himself to cross-examination. You can attack the DNA expert the state will call, attach the machinery, attack the method, argue for, admittedly really flimsy and stupid, alternative explanations for why that DNA got there. The confessions, though, your only line of attack is really that they were lies. So, you have to get evidence out about that. The lawyer's arguments / statements aren't evidence, and establish some sort of motive for the lie. This is only really possible if Chris testifies, and that opens him up to cross-examination. Chris will definitely not hold up well under even a gentle, polite cross. Okay, but wasn't this entrapment? I've seen this one a lot too, and the answer is also no. Entrapment is only a defense where the government does it to you. random trolls convincing you to do it doesn't meet the legal standard. Also, part of entrapment is a defense, is that it's not something you would have done on your own. And based on some sort of Chris's past statements, that might be a reach. Fine, but Chris is crazy. They'll just get him off with an insanity defense. Not exactly. See, legal insanity actually has a specific meaning. It's gonna maybe vary a bit in Virginia, but essentially the standard is that you were so insane at the time of the crime that you couldn't appreciate what you were doing and that what you were doing was wrong. It's perfectly possible to be screamingly clinically insane and yet legally sane. I've seen it, a lot. This can mean that you're not competent to stand trial and assist in your own defense, but all that means is that the action is halted while we send you to an institution for treatment, and once you're stabilized, we get you back and finish it up. Also, not guilty by reason of insanity wouldn't really be getting him off, because despite being found not guilty, he would be committed to a mental institution indefinitely until he was no longer criminally insane and a threat to society. That can, and often does, mean the rest of a person's natural life. Now, I'm told there's a Virginia law that allows someone to use their autism as a mitigating factor to avoid custodial sentence. But that isn't the same thing as getting out of it entirely. It just means that you're more likely to get probation, which brings us nicely to... Okay, you've convinced me, so this means the start of the prison saga, right? Not yet. You see, a prosecutor's job isn't just to slam everyone into prison as fast as possible. As the U.S. Supreme Court put it, a prosecutor is the representative not of an ordinary party to a controversy, but of a sovereignty whose obligation to govern impartially is as compelling as its obligation to govern at all. And those interests, therefore, in a criminal prosecution, is not that it shall win a case, but that justice shall be done. What this looks like to every prosecutor is a little bit different. There's a lot of consideration that goes into what justice looks like on a given case. A big one here is the victim. I suspect that it will eventually come out this $750 is a drop in the bucket in terms of how much of Barb's money Chris has spent. There's also the fact that Chris does have mental issues, and remember, Virginia prosecutors may have to contend with the autism mitigation. And this was a very unique set of circumstances that allowed this to happen. Chris isn't a high risk to reoffend in this matter as long as he's supervised, treated, and not allowed around Barb. And Chris's criminal history is negligible, although it certainly proves that he doesn't deserve any kind of probation that allows him to avoid conviction. Not that I would offer it on these sort of offenses anyway. So, if this were my case, the proposed plea deal would probably look a little like this. I plead guilty to a single count of rape, a single count of financial abuse of the elderly, and a count of violating a misdemeanor. In exchange, what many jurisdictions call a suspended sentence, this is a form of probation, but it counts as a conviction. The incentive isn't to avoid being convicted, it's to avoid prison. So, Chris would now be a convicted felon and a registered sex offender. Also, there would be a course of conditions to the probation. Meeting with a probation officer, sex offender therapy, regular therapy, no contact with Barb, and restitution, making the victim whole, so every month he's going to give us a set amount to put back into her pocket until the money he took out is paid back, would be some of the conditions. The other thing you have to understand about a suspended sentence is, as part of the deal, you agree to a sentence within the range of the crimes you pled guilty to. If you violate your probation and it's proven, and the burden at such a hearing is lower than the beyond a reasonable doubt needed to prove you guilty, and there's no jury right at such hearing, the court will impose that agreed upon amount of prison time. I'd be asking for an agreement to something in the upper end of the range. And, let's be honest, we all know Chris would spectacularly fail probation and get revoked within the first 6 months, and then the prison saga would finally begin. But if this does go to trial, they'll have to watch the documentary, and Kiwi Farms will be put into evidence, and Gino and Null will be expert witnesses, right? I'm sorry to disappoint you, hypothetical reader, but no. For one thing, there's a rule called the hearsay rule. We can't just introduce whatever statements made out of court we want into evidence, and essentially this is a rule about fairness and reliability of evidence. There's an exception for statements of a party opponent, which in this case would be Chris, which allow for the videos Chris made without extra commentary to be introduced. They still likely won't because evidence has to be relevant, and also more useful for proving something than it is harmful to your opponent. We call this the prejudicial versus probative. In a case where the charges are Chris raping Barb and Chris abusing Barb financially, 99% of all this nonsense is not only irrelevant and doesn't prove anything, but it is also insanely prejudicial to Chris. But there is a chance Null, for example, might be called in. If they want to show the jury the messages where Chris admits to taking the money, they would need Null to help authenticate that piece of evidence. But it's easier just to subpoena the bank records and so forth and show that Chris did it that way. And that's the reality of most of the evidence. The admissions by text, subpoena the text messages from Chris's cell phone and show that they were sent by Chris. And remember, by the time we're going to trial, there's been at least one, maybe more interrogation or interviews. And there's no way Chris doesn't spill his guts, especially when faced with the text and the call and everything the police tell him they have. He'll do what criminals have always done and attempt to explain his way out of it. And, in reality, those are the tapes that will be played at trial, not the calls, not the texts. All of that may well be reduced to a byline by the direct exam of the police detective, where he or she explains how the case came to their attention. TLDR, if this is as real as it seems to be, Chris is pretty fucked. It's unlikely to go to trial, nor will Chris go to prison right away. More likely a plea bargain for heavy probation, leading to eventually spectacular failure and revocation into prison. If this does somehow go to trial, rules designed to ensure the fairness of this process will prevent the jury from learning 99% of the story that is Chris. Edit. Having been shown the relevant laws, there is zero chance Chris's gender plays a role into any criminal charges available. Well, there we have it. That's the post by Mr. Alexander Hamilton, a Kiwi Farms user. Thank you for watching this far in. I really appreciate it. Gotta say, I wasn't expecting anywhere near the amount of success that I got from the past two videos, so I just gotta say thank you. YouTube algorithm is really pushing me through a little bit, so I'm very happy with that. I really don't know what to say about Chris Chan anymore. At one point I was completely fascinated with his plight, but now it's more and more disgusting and more terrifying. So I'm just gonna say thank you and see you next time.